Welcome to the Supreme Petition. Of course, this is a show that takes you through all the proceedings that happens and breaks them down, just in case you aren't able to follow accurately and decipher for yourself what happened. This was day 3, the last day in which all the sides were able to speak to the Supreme Court bench and try and convince and argue their cases, and also answer the critical questions that were posed to them in yesterday's session. And of course, we had the IBC trying to convince the Supreme Court judge bench that they held a credible election. We had the IBC doing that. On the other side, we had the petitioners answering questions, and at the same time also doubling down on some of the issues that they were trying to bring out, as well as the side that is defending the win by President-elect William Ruto, and of course also defending themselves and pushing against the petitioners. Now let's take a look at how we got here. It all started at the pre-trial phase, where a number of guidelines were set. It was a pretty easy day, and on this day the guidelines were set, and this of course included the timelines, how long this is all going to take, and also the allocation of times or the timings for the petitioners. So each of the petitioners and those representing the petitioners were given an allocation of time, and this is when we knew how this is going to play out throughout the 3 days. And then we had day 1, where we had the petitioners coming out strong and speaking to their, of course, case, and trying to convince the bench that there was a case to be heard, and of course discrediting the other side. And then we also had day 3, and on day 3, or rather day 2, this is when the respondents, the ones, the lawyers defending the president, rather president-elect, came in and tried to defend that win. And we had the terms such as fiction coming out, of course speaking to the evidence that was given. And then it came down to day 3, and that was the last day where answers were given to the questions that were posed by the bench. And of course this is the last day, and then we are going to move on to day 4 and day 5, where we are going to have the judges retreat to write down their judgments. And as they say, it's not over until the fat lady sings, and that is going to be Monday, where the judges will come out, and this might be the end of it all, and we will know what the political future of this country looks like come Monday. But before that, we would like to break down some of the issues that came out on day 3, which is today, and we'd just like to listen in to what was said in the Supreme Court today. So let's take a look at some of these sound bites.
And I do not want to go too much into this. The question of the infrastructure, what the IBC called the impregnable military style infrastructure, I think it's been demonstrated that it was certainly not at a military grade. It might be important to note, Your Ladyship, my lady, that the one question they failed to answer was, why was there stoppage of the streaming of the results at Bomas? They have not answered that, because that military grade infrastructure was obviously compromised. My lord, my lady, we say that it is bad to have a sovereign institution that is captured by the state, but it is worse to have one that is captured by foreigners. We submit that is the position in this one. Your Ladyship, my lord, the question here, and that's my third and last point, is really very simple. And it's a question that draws directly from Article 138(3)(c) of the Constitution. It is very clear, it is mandatory, that once results are received, the IEBC, not the chair, shall tally and shall verify, then shall declare results. If the IEBC as an institution has not tallied, has not verified, then there are no results to be declared. We wish to submit that at the end of this analysis, it is not a question of whether the chair is a hero or otherwise. It is a question of whether the chair did what was expected of them. It is not enough to say that there are certain regulations by the first respondent which they themselves made, and now they wish to rely on to breach the express provisions of the Constitution. We wish to submit, Your Ladyship, that in accordance with Article 141, only if there's a result properly declared can you even move to challenge it. In this case, none was done. Your Ladyship, what the chair is inviting you to do is unconstitutional. This bench comprises eminent persons who are involved in the process of making the Constitution, as some of us on this other side. There's a good reason why we've created constitutional commissions and independent offices. If it was intended to create the chair as what was previously called the supervisor of election, there'd have been an independent office, like the Auditor General, Controller of Budget, like the DPP. But now the chair is inviting you to find that his is some sort of imperial chairmanship or chairpersonship in defiance of the Constitution.
First question was to do with the question of unutilized ballots and how they are accounted for. This is the way unutilized ballots are treated. At Regulation 69, which provides for the voting procedure, that is the Regulation 69 of the Election General Regulations, it provides that a voter will be issued with ballot papers for all elections in a multiple election, that is at Regulation 69.2. At 69.2a, he is expected to cast his votes in respect of all the elections. 69.3 makes it an offense for a person to knowingly fail to place his or her ballot paper issued to him inside a ballot box. But at Regulation 77e, an unmarked ballot is treated as rejected and is void and shall not be counted for purposes of declaring a result at the polling station. At Regulation 78.3, the presiding officer then is put under an obligation to record in Form 41 the head of rejection for each ballot, and for our purposes, Sub-Regulation 3D then addresses the question of unmarked ballots. Regulation 81B then provides that rejected ballots, such as the unmarked ballots, are sealed in a tamper-proof envelope and placed in the ballot box. That is how they are accounted for, Honorable Justice of the Supreme Court. The second question that I shall deal with, and this again it was posed by His Honorable Justice Mr. Ouko, was whether the appointment of the chairperson as returning officer was as an agent of the commission or as a national returning officer in his capacity as chairman. This is how I would wish to address this question. It is a direct one, and the answer lies in the Constitution. Article 138.10 places an obligation upon the chairperson of the commission to declare the result. So the gazettement was not for purposes of Article 138.3c, but specifically for Article 138.10 to fulfill that role, to take up that responsibility, to account for that result that follows a presidential election. That is the specific purpose for that gazettement. But while I'm on this question, I would also want to pose another question. Would it then mean that if the gazette notice was to fall away, would it then mean that the chairperson of the commission under Article 138.10 would not be in a position and suffer lack of constitutional authority to declare that result? My answer is no. In other words, the gazette notice is purposely to tell Kenyans that the Constitution has rested these obligations upon this office to declare that result.
Is the relevance of rejected votes in the counts of the election. This is a matter that we have asked the court both in 2013 and 2017 to relook. We wish to resubmit as we resubmitted the two times, and to say that it is still our position that people who come out to vote, whether their vote is counted or not, are coming out to make a stand on the issue, and whether either due to technicality or other reason their vote is not counted, they must be not treated as those who stayed at home. They are people who came to express an opinion on how they want to be led, but for various reasons their vote was not counted. But the fact that they appeared should be taken into account, so that you would consider their votes, whether they are rejected, and even if they are called stray ballots, should also be considered in that sum. The second question was regarding the scientific whether there are any scientific studies regarding the nexus of elections in a postponement. We have seen, unfortunately, we could not tender any further documents of this, but there are very many theories in political science, one of which we came across with the contagion theory, that elections affect each other. People come out to vote for various reasons, and especially when you're dealing with elections of a national level and a devolved level, there are very many considerations that would make somebody want to come to make a decision on a devolved government or a national government and not necessarily care about the other. But one of the things that we also must consider in Kenya's political culture is that in Kenya we do have six-piece kind of campaigns.
All right, ladies and gentlemen, that is just part of what was witnessed today in Supreme Court. And with me to dissect what happened and just talk about some of the arising issues from today's proceedings, today being the last day, Suleiman Bashir, George Kithi, and Morara Omoke, who are actually lawyers. Now, Morara, I'll start with you. We saw you on TV during the day. Could you explain to us the exemption that you have, if I may call it that?
We have to do our best.
Yes.
We made our presentations across the last 3 days. Today was basically for the petitioners to make their final argument. And I think we did our best, so we leave it to the judges to make the determination.
Yes, indeed. We're not going to go into the merits and demerits and possible outcomes of this particular case, but we also have George Kithi and Suleiman Bashir. I'd like to hear from both of you. What do you think? This is the last day of those hearings. For the next 2 days, the judges are going to spend writing down their judgments, and then on Monday, we're all going to know what's what. Now, what do you think? What has stood out for you? I'll start with you, Mr. Kithi.
I think for purpose of the benefit of the listeners and the viewers is that this case was allocated 3 days. The first is basically the accusatory note, where those that make the accusations, who are the claimants or plaintiff or petitioners, whichever name depending on circumstances, make their case out. Then it's not usually very heated that time because it's logic law and basically the presentation, a few punctuations here and there. Then there's a case for the response, which basically are the ones that are accused. Those are the ones that try to defile the accusations and trying to render them, unacceptable in the circumstances. And that's where the other group was responding. The case itself, what matters is the last day. So that's the time when there are summaries. Now, that is what happened today. That's why you could see there are more activities today in terms of the exchanges. But more importantly is that the summary is what you've had and how you sum it up. And that becomes more important because the last word becomes the testing word. Now, for today, I think the crux is it was more arguments about law on account of the fact that the facts are settled. What was to be said was said on who did what and who did not do what. But now it's about the law. Fortunately, there's a basis for this, that we've had already Raila Odinga before, we've had him in court, he's nullified elections before, and the law was set on what needs to be done, so there were expectations and something to pick from as we develop the law. Then there was Maina Kiai, who did a very good job in terms of presentation of the law and summing it up on a blow-to-blow account of what needs to be done in an election. Now, this is very important. We must tell Kenyans this is very important because it settles down expectations. An election is more of an expectation on when I vote. How is my vote that ballot, the vote that's carried in that ballot, how is it going to be marshaled, how is it going to be administered, until then I pronounce myself in terms of my voice. So that then we're able in the next elections to expect that a ballot paper shall be handled in a certain way, and then the working environment should be in a certain way, and the weight of the vote is in a certain way. What has come out again in terms of settlements, probably to sum it up, is figures versus law. Now, figures is what we call the quantitative test. Right. Where then does the figure count and how has it been handled? That vote that cumulatively becomes the figure for the winner or the loser. And ultimately then is a qualitative aspect where we look at the quality of the process. Right. Remember, the process is also very important. You can be a winner, but if the process has been completely mishandled, that we can't even know where it has come from and where it has reached.
And that's why the heat is on
that's
the
why we say it has to be verifiable, to be verified and followed through. A journey that it is transported until the end. Absolutely. When it reaches the end, it must be able to look at the back and the footsteps that it has traveled be able to be determined. Really, that's some total of it. But of course, in there, many rules, many laws, and the Constitution ultimately.
Absolutely. Bashir, what stood out for you?
I think for me, I've come across a court of law that has tried to give every party the necessary timing that they required. We have seen actually a scenario whereby some of the councils or some of even those petitioners who are self-represented even at times just rose up on their feet and walked over to the mic, and the CJ tried as much as she could to accommodate their view, even in as much as she was trying to guide them about the time allocations and everything. So I think for me, it was more of a court that has tried to accommodate all the parties to give them an opportunity at least to be heard. But I think one of the issues that I wish to firstly appreciate is, as a country where we are today, we are staring at a presidential petition. And I think this is said to be the fourth, because in 2013, then twice in 2017, this is the fourth one. We have a court, a Supreme Court that is encompassed of at least 5 of the 7 judges who have previously presided over the previous presidential petitions, meaning these are brilliant minds who are well cut enough to give us the necessary judgments Kenyans are looking forward to. Right. But I think, again, on the other part is we also have to give so much credit to the petitioners, because we have presidential candidates who have contested and were not happy with the outcome. But now where we are as a democracy is they have now opted to subject themselves to the due process of law. So they are now sitting back and waiting for the outcome which we shall receive maybe in slightly over 48 hours. Yes. But Trix, one of the things that I keep mentioning is a good write-up that was done by Ugandan judge. She's a professor. She's called Lilian Tibatembwa. She talks about annulling a presidential election is a case-by-case analysis of the evidence before you. Right. And that courts of law should not be scared to annul a sham election, meaning the courts should at all times give the various parties their opportunities, have a look at the evidence adduced, and where it calls upon it, annul the election, as we have seen in our country before. Right. And I think as a democracy, we have our courts of law have set the pace to maybe force the rights of the people where it has manifested itself in accordance with our constitution. But I think it's a wait and see thing. But I think we have seen top minds sharing the podium, maturely engaging each other, and a good court of law that had all the timing. At times, actually, like yesterday even, it extended beyond the 6 p.m. hours. So judges have tried, and they shall have their over 48 hours to make the decision.
All the timing, all things considered, because there has been the argument, Morara, that time is such a limited resource in this particular process, and the judges are going to have only 2 days to write down their judgments. I mean, what do you make of that?
The time is set by the Constitution.
Yes, indeed.
And it was for good reason that an election like this usually puts the country on the edge. Everyone is waiting for the outcome, and when there's an outcome and there have been some complaints or some sort of dissatisfaction with the results, the people still expect that grievance is quickly resolved. So it's the nature of the dispute, the nature of the elections in our country, given the history, that we have to do them quickly. Because previously what was there is that such cases would go on for years, probably for the entire presidential term. So we have to have them done quickly. And you see, for the Supreme Court, their main assignment is to determine presidential election disputes.
Right.
So since this happens once in 5 years, then they have to do their best. Everyone has to give their best during this period.
Right. Despite the time constraint. Kethi, what do you make of that?
Absolutely.
Well, a lot of what we find in our constitution today is based on history and experiences. So while drafting the constitution and debating on it, we were looking at our past, and therefore our approach was more on deterrence, which we call the mischief rule, where you legislate in order to prevent something from happening.
From history, based on history.
And even now, when the directions come from court, because there will be directions on what needs to be done, legislative recommendation, and so on and so forth, because the court is allowed to give those directions, eventually it is to prevent what then the complaint is now, whether there be annulment or no annulment.
Okay.
Some of the things are administrative gaps that are still there that needs to be either to put regulations on the same, and others are strict provisions of law. However, what is important is to note that we are becoming accustomed to a dispute that's presidential.
Yes.
The emotions are more manageable now. Kenyans probably have received this dispute and the battles more reserved as opposed to earlier, and it is possible to vote and allow the courts to do their thing as we move on with our lives. And therefore the culture that is setting in is that Kenyans are able to vote and move on with their lives, which is very important.
Right.
However, we seem to be granting the courts the opportunities of trust, that we're beginning to trust the court to be an arbiter between protagonists in an emotional, otherwise an emotional battle such as this. But there's something important here to learn. When we put up our constitution in terms of the articles that we put, we were going to remove a lot of powers from the presidency.
Right.
Two reasons. One is we don't want an imperial president. But number two is we also wanted a situation where there is no emphasis on the presidency, that we don't have to fight over it. So we put some powers into devolution and some powers into commissions and institutions.
Sure.
Now, we haven't probably seen, this is the beginning probably of 10 years anniversary upon which we've enjoyed devolution. So probably that's another reason that we've seen, you know what, my life is at the county level.
Yes.
My governor becomes more attached to me in terms of immediate experience on how my life is managed, as opposed to the president, because they're distant away from me. So by and by, we're beginning to see the scramble is more at the county level than even the presidency. When we manage to do that, then presidency becomes a formality for purposes of the CEO of a country, as opposed to an endowment to resources and availability of resources. Because eventually, earlier on, what we've been looking at is once a certain group of people, be it the ethnicity part, be it a certain class, be it a group of people, whatever group, if they have the presidents, they have more access to resources. However, what we're beginning to see now is the access of resources is available and guaranteed in the constitution at devolution level.
Right.
So we're able then to procure a process such as antagonistic as this in terms of the court process without the emotions that we've seen, and we are more settled and subtle about it. And I think we need to commend Kenyans, because the last time we had this case, I mean, people were protesting outside court.
Absolutely.
When there's counting, people will be outside court carrying banners, and you know,
there was an intolerance towards the
but we're more tolerant now, which
trust
is very
we were
good.
giving to the courts. He's spoken about culture, the culture we are building, and one would argue that we're also building a culture of a non-acceptance of the outcome of the IBC or whatever body shall be overseeing the election. What do you say about that? Are you for the more trust to the judiciary, or less trust, and which would mean then less trust to the IBC, or how do you see this growing our electoral culture?
I think generally we are supposed to have a lot of institutions, a lot of trust in our institutions.
Yeah.
But I think one of the things that is demoralizing is the scenario we are finding ourselves before. At the moment, with the dispute that was before the Supreme Court, we have had a scenario whereby we have had two factions of the IEBC, and I think that sends a very, very bad signal.
Right.
I know it contributes to that mistrust that Kenyans might end up having in the institutions, and I think that's a bad thing. But I think on the flip side, the Maraga-led court into the 2017 special decision is what has given a lot of Kenyans a lot of faith. Remember, sitting back to make a decision on the outcome of a presidential election is not something small. It's a huge issue. And I think according to the Maraga-led team, they realized, according to them, that that particular election was not conducted in accordance with the law. They were not intimidated, they were not scared, and they ended up rendering a decision against the president-elect at the time.
Yes.
And I think that is what has given a lot of faith in the people of Kenya. Meaning, even as the main petitioner, in as much as he is a bit uncomfortable with the decision or with the outcome of that particular electoral process, he has found himself, or he has found a lot of comfort in submitting himself before the Supreme Court. Look at it this way. I think the time we ended up casting our votes was on the 9th of September. 7 days down the line, we were awaiting the outcome of that particular process. So Kenyans for 7 days were waiting for the outcome of that result. Now, since then, someone has filed a petition. Again, a lot of tension for the next 14 days to await the outcome of that particular process. But all along, we have not come across a scenario whereby Kenyans have been having a lot of problems. That is cumulatively 21 days of the people of Kenya waiting for the final verdict as to who shall be the CEO of our country. And Trix, I think one of the things that has actually contributed to our growth in terms of how we handle our electoral process is the Kriegler report. Remember, in 2007, it had a look at the integrity of our elections, and it had a lot of focus on the tallying, identification, and the announcement of the declaration of the results. And that particular report is what has recommended that we at least employ technology in undertaking our electoral processes.
But then there's still some hitches. If the case we are hearing has anything to go by, still there seems to be a lot of hitches, especially at the last point where Chebukati is having a lot of fingers pointed at him.
You see, Trix, you have a petition in a court of law. He must come up with his own grounds to maybe convince the court as to why he wants to have the court think along a certain line. Let me tell you this. Today, even as the judges were leaving their seat, ordinarily when you attend a trial and you submit before a court of law, by the time a judge is leaving his seat, that particular judge has at the moment made up his mind halfway as to how the scale of justice tilts. That tells you must adduce the necessary evidence that you wish to rely on before the court. In this regard, we have the petitioners who are still questioning that particular technology, the technology that has been applied in conducting our elections. Be that as it may, look at the progress we are making. I do not think we are where we were in 2017. The IEBC has had a lot of opportunity, especially their team, to explain to Kenyans at least how their process is what they were calling the military style of protective manner. Now, I think looking at, just as my learned senior has said, the Supreme Court decision shall try and attempt to seal, shall identify and even recommend to the legislator on how to seal those particular loopholes. Remember, since 2017, there were certain red flags that were raised. Those loopholes have never been sealed, and that is why we are still
it's a growth trajectory.
Correct. And I think if we look at the recommendations around the decision by the court, the recommendations as to how we should seal those particular gaps, if we try and abide by those particular decisions, our election come 2022 shall be better than what we have had.
So what you're saying is basically that we are flexing an electoral muscle as we move along and as these cases are heard by the Supreme Court. We're going to take a short break. When we come back, we shall talk about that and also how this actually affects the law and electoral law, more specifically across the oceans, across the world. Kenya is actually setting a certain precedent as far as this is concerned. We shall be back in a moment.